Hi there. Good afternoon or good morning, wherever you are at right now. My name is David Staus. I am a partner here at Husch Blackwell and a member of the Privacy and Data Security Practice Group. If you're looking at the screen, I am the gentleman on the bottom there, the bottom picture. With me here today is Robert Bauman, also from Husch Blackwell and also a member of its Privacy and Data Security Practice Group. He is the gentleman on the top of the screen. Listen, we've got a lot to talk about today. We're going to dive right in. There are a couple just preliminary matters that I should tell you about. First is there's obviously a question and answer function as part of the webinar. We encourage you to ask questions. The reality is we've got a lot of material. We're going to try the best we can to get to your questions. If we don't, we'll go ahead and follow up with you via email. We get a list of those questions, and we can answer those via email later. So please excuse us if we don't get to your questions. The second thing is CLE. This is approved for CLE in Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, and Texas. It is pending CLE accreditation in Wisconsin. I'm being asked to tell you that to report your hours in Illinois, Nebraska, Tennessee, or Texas, you need to click on the CLE widget at the bottom of your screen. And also tomorrow you'll get a recording of the webinar if you're just desperate to hear it all over again. But as part of that, you'll get a certificate of attendance as well. So hopefully that takes care of all the CLE information. I know nothing more about CLEs, so I've exhausted all my knowledge as far as that goes. So let's jump in then. Listen, I think it makes sense to start with this quote. And this is, for any of you who have followed RSA over the years, RSA happened a couple of weeks ago. It was a large cybersecurity conference, and one of the keynote panels was about the CCPA. And this is a quote. It comes from two of the chief privacy officers that you'll recognize, the companies, Uber and LinkedIn. And essentially, what they're saying is, and this is just as of a couple of weeks ago, telling you it's time to start compliance, right? And so if this convinces you, hey, yeah, it is time to start compliance, then the question is, well, what does compliance look like? What do we need to do to go from here to there to ensure that we make sure that we're doing what we need to do? That's what we're here to talk about today. We're dividing the presentation up into three parts. The first part, which I'll turn over to Bob in a second here, is going to be a brief overview of the CCPA. And frankly, we're not going to spend a ton of time on this today. We're anticipating that most of you are familiar with the CCPA, and what you really want to hear about is our vision for what compliance looks like and what you need to be doing now. But for those who are unfamiliar, we wanted to give you a 30,000-foot overview of the CCPA. And listen, we've got lots of resources that can bring you up to speed on these issues. So feel free to email me or email Bob, and we can get you those resources if you need more context after today. The second part, what you need to do now, that's the part that we're going to spend a substantial amount of today talking about. And the goal is that when you leave here in the next hour, you're going to understand what the task ahead is and what you need to do to drive after compliance. And the last part of it is the what's to come. What do we expect to have happen over the next few months as the legislative and regulatory process works through, as well as talking about what some other states are looking at as far as privacy law. So before we begin, though, I think it's important that we start with this disclaimer. If you know the history of this legislation, you know it was enacted hastily over the course of just a few days in California. Really remarkable given the scope of what this legislation is, just how quickly it came to pass. There's a lot going on now to try to fix this legislation in the California legislature. There's regulations that are to come as well. But it's important, I think, to level set at the beginning and realize there's just a lot of things in this legislation that don't make sense. And we're all doing our best to navigate that, and optimistic that some of these things will get fixed by the time the legislative session is over in a few months. With that, let me turn it over to Bob to dive in and give you that 30,000-foot overview of CCPA.
Hello, everyone. Thank you for taking the time to join us today. So if you get under the hood a little bit, the CCPA is really directed towards commercial entities. And so the businesses that are covered by the CCPA are for-profit legal entities. That's the base requirement, plus one of three different qualifying conditions. One is a annual gross revenue in excess of $25 million. The interpretation now is that's global revenue and not just allocated to revenue generated out of California. 50,000 people, so collecting, buying, receiving for commercial purposes, selling or sharing commercial purposes, the information of 50,000 or more consumers, households, or devices. Consumer, as defined in the statute, means a California resident. Households don't really have a clear definition right now, so that's one of the things we hope that they clarify as they fine-tune the legislation. Or if you derive 50% or more of your annual revenue from selling consumers' personal information. That seems to kind of be targeted towards data brokers, but we've also could also contemplate sort of free share applications, like Facebook or LinkedIn, where you don't charge anything, but part of your revenue or most of your revenue is generated from the use of collecting and using personal information. So you have the for-profit entity plus one of those three things, or an entity that controls or is controlled by a business and that shares common branding. Control or controlled, is sort of the contractual definition of an affiliate. So you have the ownership of, the power to vote more than 50% of the shares. So, and then common branding means that you operate under some shared name, service mark, or trademark. So that's just generally what entities will be covered by this. And as you can imagine, there'll probably be some gray area that we'll need to kind of do some analysis for each individual client. Let's move on here. One of the major aspects of the CCPA is it's greatly expanded the definition of personal information. And so it's defined in the statute as information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. You'll see we've kind of provided a line item list of the ones that are expressly mentioned in the statute. The AG and their coming regulations is going to try and find a little more definition around that. But essentially, if you collect any information, you're collecting personal information. You see IP address is listed as one of the items of personal information. So if you log visitors to your website, that probably will qualify you under the California privacy law as written. So some of you probably are familiar with the GDPR, and the way that the GDPR differs from the way that privacy had been at least handled in the U.S. is it enumerated basic rights for individual consumers regarding the use and collection of their information. The CCPA follows that. GDPR, I believe, has seven rights enumerated. CCPA basically has 4 that are really consumer-centric. One is disclosures, so it follows along the privacy rubric of consent and notice and consent. So disclosures, you have to disclose what personal information you collect about California residents and how that information is shared with third parties. Consumers have a right to access, so they have a right to contact people who have collected their information and receive information about the specific pieces of personal information the business has collected on the consumer for a 12-month period prior. And that 12-month period prior is important. I think David will kind of address how that comes into play, why you may want to start considering compliance efforts now. The right to be forgotten. So this is another interesting one that's included also in the GDPR, and it really gives the consumers a right to notify an entity that it believes has information collected on them and have them delete all of the personal information that they have on them. Now, there's some exceptions to that, obviously just to carry out business or perform some functions. But essentially, systems need to be set up and designed so that if they receive a right to be forgotten notice, that consumer can be permanently deleted from the data stored. Opt out of sales. So for businesses that do sell personal information as part of their business, they must provide an online mechanism so that individual consumers can opt out of their personal information being sold to third parties. You know, again, this creates an additional administrative and technological burden on companies that are collecting data. And part of what the AG is going to address is how that's accomplished and in what form that needs to be presented to the consumers. Enforcement. They say, well, what if I don't want to comply? What can they do to me? So the California Attorney General is enforced or has the power to enforce the general provisions of the Consumer Protection Act, with statutory damages of $2,500 for each violation or $7,500 for each intentional violation. So right now, one of the things we hope they will clarify is it's unclear how violation will be applied. But if it's on a per user basis and you meet the minimum 50,000 consumers, 7,500 times 50,000 could add up pretty quick. One of the unique things about the CCPA is also a private right of action, and this is individual consumers can have a private right of action for damages due to data breaches. Statutory damages right now are set between $100 and $750 per consumer incident. Again, there's gray area on what per consumer incident applies. And what this really dictates, while it's not expressly stated through this private right of action, there's an implication that reasonable security measures must be taken in order to protect the consumer data. And then for more information, David has just issued, I think it went live yesterday. Yeah. Kind of sort of a guidebook to the California Consumer Privacy Act. That's available on our website, or you can reach out to either one of us, and we'll make sure that we get a link sent to you so you can download that if you're interested.
Thanks, Bob. And on that note, so I've been looking at some of the questions that came in about the scope of the CCPA. And I think, fortunately, I think a lot of the questions that you're asking are answered by the guidebook. I'll go ahead and follow up with the people who are asking those scope questions after the webinar about the exact context in which, you know, the definition of business and et cetera. And please note, I'll be happy to reach out to you and answer those questions. So listen, I mean, well, obviously we talked about giving the 30,000-foot overview of what the CCPA is. The real brunt of today is focusing on what you need to do to drive after compliance, right? And let's start here. This is the timeline of where we sit and where we envision this ending over the next few months, right? First, it's important to note that the first date that we see there is the 12-month look-back period begins. So Bob just mentioned that the statute includes the right to access. So essentially a person can come in and ask you to produce all specific pieces of personal information. Remember, with that broad definition of PI that he showed to you, and you've got to produce that information for the prior 12 months, right? There's nothing in the statute that says that begins, the look-back period begins as of January 1st, 2020. Instead, the common assumption is that we're already within that look-back period. So as of January 1st, 2020, when you have to respond to verifiable requests, you're going to have to produce specific pieces of personal information for California consumers, right, California residents, for the prior 12 months. So we're in that look-back period. The deadlines for public comment have passed for the AG's regulation, You see the, you are here flag at the bottom there. We'll have the end of the legislative session in September. The governor has a month after that to sign any legislation. We anticipate draft AG regulations in the fall, and then the CCPA is going to become effective. Now, think about this, right? The draft regulations are going to come into effect, be published in the fall, but just draft. The CCPA will become effective. People can submit to you verified requests to access and to be forgotten as of January 1st, 2020, even though there's an absence of final regulations from the AG's office. The caveat is the AG's office is not going to be enforcing the violations of this until it issues its final regulations, which it has to do by the end of, or the first date of July, okay? But it doesn't mean people can't be asking you these things, and it doesn't mean that people cannot be complaining that you're not responding to this. And it does not mean that the Attorney General's office cannot be logging who is complying and who is not complying. And in fact, there's indications that they will be, and taking that into account even prior to the time in which they can enforce the violations here. Also, the data breach, Bob just talked about the data breach statutory damages. That goes into effect January 1st, 2020. So the bet the company litigation data breach damages goes into effect in January. So let's talk then about the roadmap to what we envision compliance to look like, the meat of what we're talking about here today. Broken this up into 6 parts, and I'm going to dig into each one of these individually. The first part, data inventory and classification, okay? So what are we talking about here? What's the issue? Well, as Bob just told you, that the CCPA requires businesses to make disclosures about what personal information they collect, the purpose for the collection, and then the sources of that collection. There's other things as well, but let's focus on this for now. And you've got to respond to these verifiable requests to access this information, and you've got to respond to verifiable requests to delete personal information as well, okay? So ask yourself these questions. Sitting here today, can you say what PI your business is collecting from California consumers? Do you know the purposes for that collection? Do you know the sources of that collection? Do you know where that information resides in your organization? And can you find all of this and respond to a verifiable request of a California resident within 45 days? And if you think, well, yeah, I could do it for one, okay, could you do it for 50 people in 45 days all at the same time? Could you do it for 100 people? So these are the things that you're sort of struggling with, right, to be able to respond to these requests. And what's the solution? The solution is Excel spreadsheet, right? So this is taken from GDPR context, right? And so if you're familiar with GDPR and you went through the GDPR compliance model, you're familiar with probably what you're looking at here, which is a spreadsheet that was published by the Information Commissioner's Office in the United Kingdom, and this relates to driving after GDPR compliance. So for some context, the UK's, the ICO over there, I mean, kind of think of, it's each of the member states in the GDPR has their own data protection authority. Think of like, I don't know, like an FTC for each member state or something, right? And so the UK was very good about publishing guidance as well as documents to drive after GDPR compliance. And this is an excerpt from their data inventory. It's available online. You can find it. And this is what we're talking about when we talk about data inventory, because a lot of this context, people use these terminologies and they differ. It's really hard sometimes to track what people are talking about. So I wanted to show you what I'm talking about here. When you look at this one here, I think the section that you want to focus on is the categories of personal data, right? Because that's what's really kind of going to be similar here in the CCPA context. And everything else flows from that. Identifying the categories of personal data, and for CCPA we're talking about personal information, but personal data is the terminology in GDPR, but everything else flows from that, right? Now the question you have is, okay, well, can I just take this spreadsheet, fill it out, and then I'll be compliant with CCPA? The answer is no, right? Because there's different contexts. There's different requirements, I should say. And we're going to talk about what a CCPA data inventory looks like in just a second. But one concept that I think you need to be thinking about as an organization is the larger picture here. as you define the scope of what the company is up against over the next few years, right? We have the CCPA. It's going into effect. If you have to comply, you have to comply. That's column one. Column two is, and we'll talk about this later, there are now a number of states that are looking at similar legislation. Washington is the most advanced. It looks like that's going to get across the finish line, right? But do you conceptualize this issue as a California issue, or do you conceptualize this issue as a United States issue for purposes of your data inventory and thinking about how you're going to go through this process? And the third part as well is looking at this globally, right? Obviously, the EU has enacted the GDPR. Brazil now has a tag-along privacy statute as well. Other countries are developing privacy regulations. So if you are, based on the footprint of which your business operates, you need to be thinking about what is the scope for compliance here. Do I just want to make it California specific, or do I want to do something larger so I don't have to reinvent the wheel every time a new state or a new government comes up with a privacy law? Having said all that, let's talk about what the CCPA data inventory would look like, okay? So I've identified over this slide and on the next slide a number of categories that would be compiled as part of your CCPA data inventory. Business function is the first one. Not technically required by the CCPA, but why is it important? It identifies ownership, right? It can also be used for data minimization. If there's not a business function linked to the PI that you're collecting, maybe you should not be collecting that personal information, right? So linking it to a business function, it's HR, it's finance, it's legal. A reason for collecting that information is important. Categories of PI collected. Keep in mind, this is a defined term. And when they say the categories of PI, they want you to link that back to all of those categories that Bob showed you earlier on that personal information slide. And there are many, many categories. So that's what you're driving after on the categories of PI collected. And you've got to disclose that. So you have to be linking that, okay? Business purpose for collection and commercial purpose for collection also define terms under the statute. So you're going to have to tell people in your online privacy notice, your customer-facing notices, what the business purpose and what the commercial purpose is for the collection, and you have to link that back to the statute and the categories there. Sources, the last one as well. Sources isn't defined in the CCPA. What I think they're driving after here is if you're getting it from contact us forms on your web pages, in person, somebody's handing over PI to you on applications, things of the like, right? Cookies, if your web page is collecting or is using cookies, and all of your web pages are using cookies. The question is, what types of personal information are you collecting with those cookies? Number 6, location of information, right? So think again back, you're thinking about that spreadsheet we showed you. This is essentially columns on the spreadsheet that you're going to be filling in. Why do you want location of information? Well, you're going to have to respond to verifiable requests, right? And you're going to have to be able to figure out, hey, if I need to produce personal information, specific pieces of personal information to people and provide that to them in response to a request to access, how am I going to do that? Do I know where it resides? Do I know what entities to be able to ask for that to be produced to, which departments I should say, right? And especially as well, to delete the information as well. Could you actually respond and delete someone's personal information, subject to 9 exceptions, of course, but could you delete that personal information within 45 days? You've got to know where the location of it is. You've got to know who to talk to, who to interact with within your organization. Recipients of information, we're going to talk a lot about that in a little bit, but you got opt-out requests, right? And so the opt-out request extends beyond just your organization. That means you cannot be giving it to third parties, the personal information to third parties. But we'll talk about that a little bit more later. Retention, how long is your personal information, how long are you retaining this, right? I think that's significant because you need to know where you're looking. And if it's gone, then you need to understand that it's gone and not look for things that's only retained for a short period of time. And also I think it's good to be grappling with these issues here on the front end of this and not keeping information any longer than you have to. We're going to talk about retention a little bit as well, though. There's some caveats here, and it harkens back to the it's a mess slide that I was talking about before, but just keep retention in mind for a little bit. Okay, so what's the plan then? You say, okay, fine, I've got to complete this Excel spreadsheet. I've got all these columns. How do I go from here to there, right? Well, listen, you can come up with a plan. This is one suggested one. First step, develop the list of employees. Who are the people that you would need to talk to within your organization? Step 2, distribute questionnaires. These don't have to be lengthy questionnaires, but it's the type of questionnaires that say things like, what information is your department collecting? Where is it stored? Who has access to it? Those types of questions, okay? Do follow-up interviews with those people. Meet with the key stakeholders. If there's an individual responsible for that business unit, meet with them. Take what you've done, relay it to them. Does this look accurate to you? Are there any gaps? Those types of things. If there are gaps, distribute additional questionnaires to individuals that maybe you missed on your first pass. And then finally, reviewing relevant policies, procedures, and contracts to identify gaps, filling in the holes there, making sure that you haven't missed anything. And remember, this is a living and breathing document as well, so it's going to change over time. And actually, the CCPA envisions this because it has an evergreen requirement that says that you need to be looking at your disclosures on an every year basis. Okay, let's move on to data classification. So here's the good news. If you are already regulated, if you're GLBA or if you're HIPAA, then the CCPA has carve-outs, right? And these carve-outs get to be fairly complicated. We're going to stay away from drilling down into it. If you have a question about that, happy to discuss with you offline. But for our purposes now, right, remember, we're creating a data inventory. We're saying, how do we collect information? Where does it go? What's the sources? Where does it reside? All those types of things, okay? If you are subject to GLBA, what the statute says is that information that is subject to GLBA, the non-public personal information under GLBA, the CCPA doesn't apply to that. But you need to do that analysis. And it's better to do that analysis today or the next few months than it is to try to do that on the fly as you're responding to verified requests. And so going through that process and identifying, hey, we have a file from, a loan file that's subject to GLBA, and in this column next to it, so that's classified as GLBA, and we know that that's carved out from the CCPA. Same thing with HIPAA. There's HIPAA carve-outs as well. Going through that analysis now and classifying data based on whether or not they're subject to these statutes will save incredible amounts of headache down the road. The bad news, these are not complete exceptions, okay? So for example, if you're a financial institution and you're collecting personal information from California residents in relation to loans, that's one thing. That's going to be set aside. But there's going to be personal information that you're collecting from California residents that is not subject to GLBA. Your marketing efforts, if you're using emails to do marketing with people, to go after leads, to try to get new customers, that's not going to be covered by GLBA, subject to the CCPA. Again, doing that analysis now saves a lot of anxiety later. 3 more things to talk about this before I go on to the next topic. De-identification, aggregation, and data retention. First 2, de-identification and aggregation. The CCPA recognizes these concepts. And there is a lot of thought, which I agree with, that the CCPA contains a typo. And the typo is essentially this. In the definition of personal information, at the very end, it has what many of us believe is they were intending to exclude de-identified and aggregated information from the definition of personal information. I think you can read that into the statute already, but I think that this is one of those areas where they're going to make it abundantly clear the next few months that if you de-identify data or you aggregate data, it is no longer personal information within the CCPA. And that is significant, okay? The reason why that's significant is because if you have these procedures in place, de-identify or aggregate, then it's not going to be personal information. You're not going to have to respond to verified requests to do that. So instituting these types of business processes, the de-identified data that you don't need anymore or aggregate it, is going to solve a lot of compliance issues. De-identification, for those who are familiar with the HIPAA context, it is a different standard. It is not the typical HIPAA de-identification process. It's different. It's worth talking about, not in this context, but in a different context about those issues. But point being, this is one of the ways that you can solve your internal issues with compliance. Data retention. this is, when I refer to it's a mess, this is one of these areas that really needs to be addressed in the CCPA. There is nothing in the CCPA that says that a business has to retain data. However, what the CCPA does say is, quote, this section shall not require a business to retain any personal information collected for a single one-time transaction if such information is not sold or retained by the business. So essentially, you are not required to retain personal information for a single one-time transaction. Think of like credit card transactions, right? But by default, does that mean that you are required to retain it for all other reasons? The statute's silent. This hopefully gets cleaned up in the amendment process, right? I mean, what's the point of saying that you're not required to keep it for a single one-time transaction, but then not talk about data retention on the other end? And remember, we have a 12-month look-back period, so that creates issues about whether you're required to keep data for 12 months to respond to the verify request to provide specific pieces of personal information. I think this issue is live. It's in front of the legislature. They're aware of it. This is an easy fix that they can solve over the next few months, is to make it clear that the CCPA does not require businesses to retain data that they otherwise would not. It goes against the fundamental principles of privacy law, which is data minimization. If you can get rid of it, then you can't lose it, right? And the statute should encourage data minimization. It should not discourage it. However, you can use de-identification aggregation as a way to solve this problem in the interim, right? Because it recognizes that de-identification, again, I think there's enough in there that recognizes that this takes it out of the context of personal information. Okay, let's move on. Part 2 of this compliance. So here's the problem. The CCPA allows California consumers to submit verifiable requests. That's the term that's used, verifiable requests, right? To be forgotten, to access personal information, be provided with more information regarding transfers to third parties. But what it doesn't tell you is how you go about doing that process. And the AG's office is supposed to be issuing regulations regarding this, but if you look at the regulations that were issued in the context of GDPR, there's not a lot of, I shouldn't say regulations, the guidance, in particular the ICO guidance that came out, there's not a lot of context there, okay? So how do you solve this? How do you go about the process of standing up a compliance to be able to respond to verified requests? Here's the 5 parts that we've come up with. We've talked about data inventory already. I won't repeat it. I'll move on to the second one, which is methods for receiving requests. So under the statute, you've got to make available 2 or more designated methods for submitting requests. So I'm a California resident. How do I go about interacting with your business to be able to actually submit these requests? Well, it says 2 or more. It must include a toll-free number, and it must include a website address. It has a caveat that says, if you have a website, but I mean, come on, who doesn't have websites at this point in time, right? So these are the baseline, toll-free number and website address from which you can submit verified requests. There's also a requirement that you have a do not sell my personal information link if you are in fact selling personal information. And we'll talk about the definition of sell later. You may be thinking, well, I don't sell, my company doesn't sell personal information. Hold tight. We'll talk about that in a little bit. What I would point out, though, is sitting here in March 2019, these are things you can address now. These are low-hanging fruit of compliance efforts, right? These are things that you can work with your IT staff on setting up telephone numbers, on website addresses. This is easily addressable issues now, right? No reason to wait any longer. The next issue, validating the request. How do you know that the person who is submitting the request is in fact the person whose personal information it is? This is a very difficult process that the statute essentially leaves open, okay? The AG's office is supposed to be issuing regulations. I do not have a lot of hope that the guidelines are going to be concrete, right? There's no safe harbor in the CCPA for this. If you get it wrong, there's no safe harbor. What there is in the definition of verifiable request, it says, essentially, the paraphrase, if you're not comfortable that you've been able to verify the person's identity, then you'll have to respond to a verifiable request. But you still need to stand up the procedure in place to be able to respond, to know that these people are, in fact, the people they are. And remember, as Bob talked about before, there's a consequence for getting it wrong. A data breach will cost you between $100 and $750 per consumer per incident. So query whether if you are turning over personal information to somebody who is not, in fact, the person whose information that's linked to, is that a data breach? There's a good argument that it is under the statute. There's a good argument that you're now subjecting yourself to those statutory damages. It's a really difficult issue in the statute. So how are you going to handle this, right? I mean, we talked about the fact that the AG's office is going to issue some guidance on this, so we can wait for that. But I think these are things that you can be thinking through now, right? And remember, on the last slide, we talked about it as well. There's a toll-free number requirement. So not only do you need to be thinking about this in the context of online accounts, right? And certainly, hey, if you're an entity and you've got people with an online account and you're going to require them to sign in to verify their identity with the online account before you provide the personal information, and you've got some verification built in. And maybe you're using multi-factor authentication as well, right? So maybe you can leverage your existing verification processes, sending text messages out to people to confirm, codes and the like. Maybe your app already has that built into it. So you can leverage those existing things to be able to drive after compliance here, but you've also got a toll-free number requirement. People can call and say, I'm so-and-so, and you've got to have a mechanism in place by which to verify their identity. And this is really a business-specific issue. And the reason why it's a business-specific issue is some businesses are going to have only certain amounts of personal information, names, addresses, emails, right? Other businesses are going to have a lot of personal information, social security numbers, loan information, financial information, you think of it, right? The businesses that have more personal information will strangely be in a better position to verify identities, right? The businesses that have limited information are going to be much more restricted in their ability to verify identities. And so it's going to be a business-specific issue. And even like I said, the ICO published extensive guidance on these issues, and they basically said, the ICO being the UK's data protection authority in the GDPR context. California has not issued guidance on this yet. They're supposed to. Hopefully they will. But we can look to the UK's guidance and kind of envision what California's will look like. And it basically says, we'll get it right? Don't do anything more than you have to do as far as verifying identity, but get it right and get yourself comfortable on this one. So anyway, this is a really difficult issue, something that I think entities are really going to struggle with. And also you can think about as well as building in something now into your platform. If you're allowing people to create accounts, well, maybe you want to do something like build into your platform security questions and answers so that you have a mechanism by which to verify people's identities on the back end. Okay, moving on. Policies, right? The next step. How are you going to handle this internally, your workflow process, right? And here's some of the questions and some of the topics I think you need to be wrestling with your business as you develop these internal policies to be able to handle it. Who received the request? At the other end of, if you've got an email address, your email address is, californiarequest@yourbusiness.com, right? Who's on the other end of that to receive those emails? And who has ownership? Is the person who receives those emails, is that going to be the same department that has ownership? Is it legal that has ownership? Is it IT that has ownership? Will different requests be handled by different departments? So the right to access versus the right to be forgotten, the right to opt out. Will all those logically make sense being handled by the same department? I think in many cases the answer is going to be no for large organizations. Will legal review the responses before they go out? You have to respond to the right to be forgotten. There's 9 exceptions to the right to be forgotten. So when you're sending a letter, the response letter out, we'll talk about in a second, is legal part of that process. When you're providing the information to people on the specific pieces of personal information, is there a check in place to make sure that you got it all, that you're confident that your production, just like in a litigation context, your production equals the request, right? So is legal involved in that process? We talked about the non-exceptions. How will you handle non-exceptions to the right to be forgotten? You want consistency there, right? How will you notify service providers of deletion requests? We'll talk about this in a minute, but if you get a right to be forgotten request, you've got to make an attempt to get your service providers to also delete that information. So you got to have that built into your policy as well and into your contracts. Internal deadlines for responding. You have 45 days to get this done. You can get a 45-day extension. How are you going to staff that internally? Are there going to be expectations after a certain amount, your intake process, and this dovetails with access request log, right? Are you logging this as they come in? Who has responsibility? What the work process flow is? When is it ready for review? Who handles these types of things? This is all part of the process you're going to have to build in. And your extensions, as well as the last topic, and I'm sure there's more, right, to think through it, but extensions is essentially what the CCPA says is you got 45 days to respond, but you can get another 45 days under the statute, but you got to notify the individual making the request within the 45 days. So when you get to day 40, you've got to be notifying somebody, right? And think about it. How are you going to notify people? If somebody calls on a phone call and you have limited information, you need to take some limited information to be able to get back to them as far as responding to their requests. Okay? All right. So the response. The CCPA requires you to respond, even if you do not take action. You get the right to be forgotten, and you say, well, this doesn't make any sense, right? You're not a California resident. We've got 9 exceptions. You hit every single one of them or something along those lines, right? You got to respond. And so drafting up your form letters and your communications, whether it's email or whether it's a letter, is going to be something that you can accomplish now because you want consistency in this process. The last thing you want is to have this to be haphazard where, depending on the request and depending on who's handling it, it gets handled in different ways, especially when you're thinking about the way that you will apply the non-exceptions to the right to be forgotten. And when you're thinking about as well about GLBA and HIPAA, remember we talked about in the data inventory before where you're going to have the data classification, and you're going to say, well, listen, this data is GLBA covered data, or this is HIPAA covered data, right? Or HIPAA PHI, I should say, to be more accurate. And so I'm not going to be required to produce this information back to people, right? Well, should you say that? Should you tell people in the response letter, we are withholding information subject to GLBA, right? We are withholding responsive information subject to HIPAA. In a litigation context, the federal rules require you to say if you're withholding responsive information. So applied into this context, it's probably a best practice to think about telling people we are withholding certain information. Plus, too, if you're a California consumer and you've come to the organization to get a loan and you ask for your personal information and you got a loan with them, that you filled out your application, you've asked for it, and the bank comes back to you and says, we don't have anything, right? You got a problem, right? So you want to think these issues through now and have these form letters. Delivery, another complicated issue. So essentially what the CCPA says is you got to give the election. And there's 2 provisions of the CCPA, they conflict with one another. The way I read them is you got to give the California resident the election of either requesting the information via email or electronic format or via mail, okay? So if they have a user account, you can push it out through their user account. Great. You cannot force them to create a user account. No, CCPA says that. So you're going to have to think about how you're going to deliver this information based on what your business model is and how you expect people to be interacting with you. If California residents request this information to be used in a in electronic format, it's got to be produced in a readily usable format. This is to use GDPR, we keep on talking about it, but this is the right to data portability. There's a lot of talk about whether or not this was supposed to be in the CCPA, but it's there right now, and unless it goes away, you're going to actually be able to you can't just provide somebody with a stack of paper, right? You're going to be able to provide this to somebody, to a California resident, in a way in which they can take this to another business, and that business load up their personal information so that they can use that. The concept behind this, when you really peel back on this, is it's an antitrust provision. Essentially, what it is, you're not the data subject, the California resident in this context, is supposed to be able to the person is supposed to be able to take their information and take it to another business. Okay, so that way it's antitrust. They're able to transfer the personal information. You're not stuck shopping at Target for the rest of your life if you want to go down the street and shop with a Target competitor. That type of thing. Okay. 3 more things. Backup tapes and a right to be forgotten. This is a big problem in the CCPA. Your entity, 99% of you out there, your entities will have backup tapes. That is incredibly important. If you have a disaster recovery process in place, then you're taking your information systems, you're backing them up, you're taking them off-site, you're storing them away so they cannot be touched. They cannot be changed. And so if disaster happens, you can go back and get your tapes from the day before, the month before, and get all of your information back, right? Okay. So if you get a right to be forgotten request, and you've got people's personal information on those backup tapes, do you need to go to those backup tapes and delete personal information from them? The CCPA is silent. It's a big problem. The entire point of backup tapes is that they do not change, that they are exactly what they were on the day that they were taken. So if you need to get your system back up and running, that you're able to do so. This is something hopefully that we will get some guidance out of the Attorney General's office on, but it's something that you're basically just going to have to make a business decision on about whether or not to involve backup tapes. In the GDPR context, they did address this, the ICO did, and essentially said, hey, if you've got access controls on your backup tapes, if they're really hard to get loaded back up on, then you're not going to have to extend it to it. If there's a lot more complication part of that, but anyway, that's the 30,000-foot level. You got to be aware of this issue. There's also the children's opt-in procedure. If you're collecting personal information for people who are 16 and under, you got other requirements. I'm not going to talk about them, but you got other requirements. There's also the anti-discrimination provision as well. So this is really a first-in-the-nation issue, which essentially is that you're not allowed to discriminate against California residents for exercising these rights. However, you are allowed to offer financial incentives in relation to this, okay? It's complicated. If you're interested in learning more, we can dive into it, but it's a 20-minute discussion alone. Okay, third-party management, disclosures and opt-out. Bob talked about this before, right? So if you sell personal information to third parties, and they're in quotes there because they are defined terms, then you're going to have to provide additional disclosures to California residents, including allowing them to opt out of the sale. Importantly, the opt-out does not extend to service providers. Again, a defined term. Now, I talked about this before. Sell does not mean sell. What you are thinking about in your mind, what a sale is, because we're all very familiar with going into a store and turning over money for products, right? That is not how it's defined in the CCPA. The CCPA defines it essentially as a transfer of personal information to a third party for monetary or, quote, other valuable consideration, right? So it's just the transfer of personal information and can be for other valuable consideration. Now, does the statute define other valuable consideration? Of course not. Like I said, again, what did we say before? It's a bit of a mess, right? It does not define other valuable consideration. What I'm guessing, though, is you're probably sitting there thinking in your mind right now, does my business transfer personal information to other entities? And if it does, do I think that that transfer can fall under the rubric of other valuable consideration? It's a really good question, and it's one in which I think I'm not convinced we're going to get regulations on point. It's not one of the topics that the AG's office has identified, but I think it's something that you really need to be thinking about, and it really drives home this third-party management issue. Now, to qualify as a service provider, so this is the distinction, right? Service providers, you're not part of the opt-out. Third parties, you're part of this opt-out provision. You cannot be transferring PI to third parties. You could transfer it to service providers if there's an opt-out. So what is the difference between service providers and third party? It's essentially contractual terms govern, okay? So you would need to have a contract with an entity to make them a service provider. You have to have a contract with that entity, and it would need to do things like prohibiting that entity from using the personal information for a purpose other than what's in the contract, confidentiality, things of the like. Okay, and we'll get into it in a little more. So okay, so we've got a problem. Here's the solution, right? Investigate. Are you doing these transfers? Third-party inventory, it would be the next part of the process, and then implementation, implementing a process by which you can address all of this. We'll handle these individually here. So first one, investigation. Identify all third-party transfers, and I don't have quotes on third-party there, right? Essentially, if your organization is transferring personal information to anyone externally, any other entity externally, you need to figure that out. How do you do that? Use the same methodology as we talked about before in your data inventory, right? As you're going through this process, embed this third-party questionnaire process as part of that data inventory. Yes, I mean, in the same Excel spreadsheet, you can just continue with other columns about whether this personal information is transferred to any other entity. That's the way it's set up on the ICO one. There's no reason that you cannot do that as well. It's a pretty intuitive types of process here. This slide here is, is part of that inventory process with all those columns. What will those columns say? You're going to identify whether it's transferred to another party, who that party is, right? But there's additional disclosures that you need to make if this is being triggered. And this is the disclosures. This is essentially what the CCPA requires. So you're going to be adding these columns to your data inventory, your third-party data inventory. If you want to separate it, your data inventory, if you want to keep it the same, and you're going to be answering these questions, okay? And then implementation. So once you've identified all these transfers to other entities, I think what you want to do in your spreadsheet is you want to go through and you want to make judgment calls about whether you want these entities to be third parties or you want these entities to be service providers, okay? And make that judgment call. If they are service providers, you want them to be service providers, what are you going to have to do at that point? Well, you have to prepare and revise contracts or contractual addendums to satisfy these requirements, right? And I said I'd talk about these a little bit. So what the contract's going to have to say, based on the statute, is that the PI is being disclosed for a business purpose pursuant to the contract. The contract's going to have to prohibit the entity receiving the information from using it for any other purpose other than the purpose that's identified in the contract. It's going to have to prohibit the entity from using it for a commercial purpose other than what's specified in the contract. A little bit redundant provisions there. Prohibit the sale of the personal information, and also include a certification from the person receiving the personal information that says they understand the restrictions and agree to be bound by them. So after you've categorized these transfers and identified which category you go in, you're going to have to think about things like, how do I get these contracts drafted? How do I get them out to these entities? How do I track the implementation? How do I make sure I've got them back, right? And then flowing that into your third-party disclosures and also into your data inventory to be able to understand if you get a request to opt out, which entities that attaches to, right? And so this process, again, is all going to flow together here. If they are third parties, if you said, okay, they're third parties, there's no way that they're service providers, okay? Then I think the next step there is thinking back to that de-identification and aggregation as a way in which you guys can try to take it out of sale. Because again, if you're de-identifying or aggregating personal information, if they fix that, although again, I think there's plenty in the statute to say that it's an exception, but even if they make it abundantly clear, if it's not personal information, then there cannot be a sale. Okay. Two more, and I'm going to go quick because obviously we're running out of time. There's a lot to be said here, as we said before. Number 4, your online and customer-facing notices. This is actually fairly short, right? So the statute requires you make certain disclosures online about what you're collecting, how it's sold and shared. Bob talked about those before. Customer notices. There's also a provision that says that you got to make disclosures at the point of collection. Okay. So what's the solution? Rewrite your policy. And if you have a privacy policy, what I'm talking about is at the bottom of your web page. If you have a privacy policy, then you've got to rewrite it to comply with the statute. If you don't have one, then you need to write one to comply with the statute. There's 3 states that have existing laws on what privacy policies require, so it's going to be a bit of a complicated process because California has existing laws, Shine the Light, as well as CalAPA. There's conflicts, and so navigating that is going to be somewhat complicated. In-person disclosures, if you're collecting information from people in person, then you have to revise your disclosures if there's California residents. A big caveat to this one here is the AG's office is charged with providing guidance on this, so I'm not sure that we're there yet, okay? What I think is, in my mind, the concept is drive after your data inventory, drive after your classifications with the entire intent that you're going to be able to address these issues after that draft guidance. But keep in mind, draft guidance comes out in the fall. The final guidance comes out in July. So you're going to be writing your online privacy notice with draft guidance in mind. But some of these concepts, I think, will eventually flow through. It's not like you're going to have to do a full rewrite or anything along those lines. I think the larger issues in my mind are, is the AG's office going to expect you to have a separate privacy policy that says something like, privacy policy for California residents, your California privacy policy, like a completely separate policy. If you're also doing GDPR compliance, I mean, at a certain point, your privacy policy is going to get so long with all the GDPR and Nevada and Delaware disclosures and the CCPA disclosures that it becomes a problem in the GDPR context if you're bound by that because you have to have transparency. And so anyway, I think the AG's office may issue guidance as to how they want this to be rolled out. 2 more slides or 3 more slides on my part, and then we'll turn over to Bob to wrap up. Information security, we talked about this. There's a prior right of action. It is bet the company damages. I don't think it's hyperbole to say that, right? Between $100 and $750 per consumer per incident. That is, I don't know how many California residents your business has. You do. Multiply it by 100, then multiply it by 750, and you tell me what the number is and what you're looking at. So the cause of action is you have a data breach, and it's due to a failure to implement and maintain reasonable security procedures. Okay? So here's the solution. You can go about this different way here, but this is one proposed solution. Do a security assessment. Bring in a third-party vendor to do a security assessment on your information security posture. Review your policies and procedures, your incident response plan, your internal privacy policy, your ITAD policy, all those things. Make sure you're using encryption the right way, et cetera, okay? Do a gap analysis and put it against a benchmark. So in California, in 2016, the California Attorney General's office said that they consider the Center for Internet Security's 20 controls to be the minimum standard of reasonable security, right? So if you want to look at a standard for California reasonable security, you should be looking at that. You should be making sure that you've checked the box on all 20, because if you're a plans lawyer, what are you going to ask for on a data breach? You're going to ask, the question, did you implement these 20 things? I mean, that's basic, right? You want to be able to say yes to all those things. Give yourself a chance to not have strict liability, essentially, in this context of the company litigation. And then develop a path forward, right, to implement and close these gaps. Okay, final section for me, and I'll turn it over to Bob. The employee training. The CCPA requires you to train your employees who are responsible for handling requests. What's the solution? Train your employees. Not overly complicated. You can figure that one out yourself. Okay, Bob, I'll turn it back over to you. You can talk about what's to come.
Great, thanks. So one of the things we're going to be monitoring here are legislative changes. So over the next legislative session in the state of California, which ends on September 13th, we're going to be monitoring what they do and providing updates. So what they're likely to do, we've kind of hit on this, fix some definitions, They'll probably remove employment information from the definition of personal information, and then they're going to fix that de-identification exception. There are other possibilities. I think there's a contingent of lobbyists who want to expand the private right of action into breaches of the statute generally, not just related to the data breach. In our view, I don't think that it's going to get there yet. But keep in mind, some of these other states that have proposed legislation have expanded private rights of action, and so those are things that we will continue to monitor. Regulations, so just kind of where we're at right now. Public forums are finished, comment period. Again, David kind of went over this. We're expecting the final regulations July 1st, but after the fall session is finished, about a month after, so maybe mid-October, we're expecting the draft regulations, which will give us a good idea of where the AG is going with their enforcement. And then just, you can read this. These are the topics that the AG is really going to define in the regulations. Categories of personal information, define what a unique identifier is, expand or define the exceptions, submitting and complying with requests, and providing guidance on how technically these requirements of the law should be implemented. And again, like we've said, so other states have proposed laws. You'll notice there's a fair amount. Washington, again, has the most momentum. We're monitoring that pretty closely, and once something definitive happens, I think March 6th, it passed the Senate. It's on to the House, and if it passed that, it'll go on to the governor and hopefully become, or maybe hopefully, depending on who you are, become law. There's also some rumblings of a federal privacy law. So there's ongoing committee hearings. You can imagine if 35 states all passed their own privacy law, that would create quite a administrative nightmare for companies that operate throughout the U.S. So at some point, I think there'll be enough motivation for the federal government to get involved. And then finally, we've had some questions on here. How will I know, or how can I keep up with the things that go on? You can subscribe to our blog, www.fightbacklaw.com. We push out fairly regular posts, and we'll be keeping a tabs on developments in the California CCPA, as long as Washington and any other states that propose legislation.
Well, I'd like to thank everybody for joining us today. We are over our time by a few minutes here. I'm cognizant of the fact that we have a number of questions that we will respond to, and we're going to get a list of those, and we'll start responding to those in the next few days. And obviously, if you have other questions that pop up over the next few days, please feel free to reach out to us. Thank you for attending today. Hope you found it useful, and hope we will see you on the blog, and hopefully we'll see you on future webinars. Thanks again.